Good evening, everyone, and welcome to today's session of Daksha Dialogues. We'll be having a conversation about public law and public law lawyering. Uh, Lawyers in the world of common law, especially, are always at the forefront of limiting government, questioning its actions, and maintaining checks on its reach. And their work plays a central role in the enforcement of civil liberties and maintaining a government of laws. Lawyers for the petitioner perform the task of questioning the state action, and lawyers for the respondents have the often unpleasant task of defending the government. Both of these are, of course, difficult things to do. Now, inasmuch as they are defending parties, the greatest traditions of the common law places lawyers as officers of the court, meaning that their first responsibility is to the court. The top law officers are considered as independent offices and not just mouthpieces of the government. I think this makes the work of the government lawyers also a very difficult one. On one hand, they have to defend the government, at times independently, while remaining committed to the law. Now, the petitioner's lawyers, on the other hand, needs to work with another set of issues. There is the presumption of constitutionality. There is often the famous reluctance on the part of the courts to pass ex parte interim orders against the state, and of course, the long time that the state takes to respond to a set of pleadings. And for a small number of lawyers, this also translates as threats to their personal safety. So the purpose of this conversation is to throw some light into the experience that lawyers have had with litigating on public law. And for this, we have two extremely eminent panelists with us, two very accomplished senior lawyers. We have with us Mr. P.S. Narasimha, who was the former Additional Solicitor General of India. He has assisted the court in a large number of cases involving interpretation of the Constitution. He has acted as an amicus curiae for the Forest Bench for many years. He has also represented India before the IT laws. He is also very keenly interested in legal education and is also on the board of some of the premier law schools. We also have with us Mr. Arvind Datar, the leading senior advocate with over 4 decades of practice. He specializes in company law, tax, constitutional law cases. All of us are familiar with his wonderful set of books. He has appeared in almost all the set of landmark cases that has happened in the last 10 to 20 years. He has authored several highly acclaimed set of books, and he is also a frequent columnist in a large number of popular media platforms. So thank you, both of you, for joining us today, and I'll welcome you to today's discussion.
Thank you.
So let me start off the question firstly to Mr. Datar. As a petitioner's lawyer on several occasions, you would have found that challenging legislation is perhaps one of the greatest public law efforts from a lawyer. Now, in doing this, he has to work against this thing called the presumption of constitutionality. Now, we find an increasing number of cases where the petitioners seek to buttress their claims with actual evidence of facts, but the courts often take a tendency to defer to the factual assertions made by the state. For instance, how the Aadhaar was safe, or how that there were no migrant workers left on the streets any longer. So what has been your experience around this situation, and how do you really get around that?
Well, actually, basically, your question is in 2 parts. One is on the presumption of constitutionality. You see, and that's rightly so. When Parliament has passed a law, there's a presumption that it is constitutional. And any person, any petitioner who challenges it, basically has to face an uphill task of challenging it. Again, now over the years, the parameters of questioning a law have been laid down. So things are in a very clear matrix. It has to be within competence. It should not violate fundamental rights. In a certain sense, not violate basic structure, and so on and so forth. Now, of course, they added new grounds like arbitrariness and so on. So the parameters are there. But nonetheless, it is a difficult task. And I find that the courts are inclined to save a statute unless they absolutely cannot help it. They are inclined to. I find a clear shift in my book. I've divided as when I analyze the cases. I find that in the initial years, at least up till 7, there was a. There was a greater chance of a law being struck down if it was bad. But when I compare those laws and I see if the same thing came today, then it would have been saved on some ground or the other. For example, in tax laws, you save it on the basis of aspect theory and things like that. So I think there is a greater reluctance to strike down a statute as unconstitutional. Statistically also, it can demonstrate it, number one. Secondly, I find that the other problem why so many laws are getting challenged is that I don't see that there is not enough of the bill being discussed in Parliament. I feel that like in the UK, you must have 3 readings. And any important bill, you can't bring it in the evening and pass it without any discussion. I think any important law should go to a select committee for discussion, feedback, and so on, and then pass. So that's another problem. As far as the factual thing is concerned, yes, that is a really serious problem, because you see, you file a writ petition to challenge a statute. There is no evidence, nobody goes into the witness box. You just got your typeset of papers and department's typesets. So I thought that not only for the government, even for the petitioner, your factual claims should be tested on a rigorous basis. You should be able to substantiate what you are saying. But you're right, there is a worry that what is said by the government should not be easily accepted in terms of proportionality. In fact, recently I wrote an article on this 4G judgment also. And if you see the judgment in England on the Belmarsh case, on the Bank Millard case in the UK Supreme Court, all have said that they'll follow the principle of strict scrutiny of whatever the state says. Just not in India, it's a universal problem, because this question of security versus liberty has been an age-old problem for the last 100, and it will continue to be a problem. But I thought that there should be a greater rigor. If the government says that 2G is sufficient to do all the applications, then you must test it. Find out whether, can you file a simple GST return on 2G? Answer is no. Can you do an online course? No. So if the government says 2G is sufficient, test it. Maybe on an extreme level, say that let Delhi be under 2G for 3 days and then see what happens. Then if it's not working, then 2G doesn't work. So similarly, I think the government claims also must be tested on a much stronger basis. The level of scrutiny must be higher, particularly when a large number of people are going to be affected by a statutory provision.
So just to come back to you on a point that came up there, is it a real deep process flaw that we have, that the summary procedure is what is exclusively available in a writ petition? There isn't really a scope for taking evidence, though probably there is one case of the Kerala High Court of the 1970s where it says that in a habeas corpus matter, we are entitled to take oral evidence, and the same principle can apply to writs too. But we have not really seen writ courts really go into a question of evidence. So is it really a case of a process flaw, and do we need to think of alternative methods where we need to have a forum or a system for collection of evidence?
No, I see, because it's not possible. Just given the sheer volume of writ petitions being filed, if you're going to allow oral evidence, then it's going to paralyze the whole system. You're right. I was told, if I'm not mistaken, Narasimha will correct me. I think in the Sabrimala matter in the Kerala High Court also, some little evidence was taken on the question of practice also in Article 226. But there are Supreme Court judgments which say that, look, in a 226 proceeding or 227, there is no evidence, there is no oral evidence, and therefore you must be very, very careful of supporting all your pleadings with as many documents as possible. And I think it may not, in 90% of the cases when you're testing the constitutional validity, there is no need of any oral evidence, because you don't have to exhibit P1, P2, etc. You can just use these documents and then argue. So to answer your question, I don't think there's a need to change the present system. Only thing is, it should be more rigorous. Like, for example, Article 32, the petitioner must establish fundamental rights. People just file 32 for the asking. And Narasimha knows more than me. I mean, very often the courts don't first stop and say, look, who are you? What are your fundamental rights?
My next question is to Mr. Narasimha. So you were the ASD for many years. You've also represented the government in a large number of cases. And the role of the law officer in this system, the government law officer, is a very tricky position according to me. On one hand, he has to argue strongly the case for the government. At the same time, he has to also remain independent to his office. Few weeks back, we read Mr. Navroz while lamenting that the government law officers no longer even concede a point. Probably I don't fully agree with that. I was going through some of the cases that you had appeared in, which was the AP Pollution Control Board or the Godavaraman case. And I think reading through these judgments, it's evident that both sets of lawyers have contributed to the laying down of the law. And both of them have played a seminal role in the way the law was shaped up. So what has been your experience around walking this tightrope?
Yeah. At the outset, thank you very much for inviting to Daksha Fellowship, particularly Mahesh, and I'm really very happy to be sitting next to Arvind, my dear friend, about whom I'll tell you at the relevant time why country needs lawyers like him in the context of independence. Before I get to your question, very, very interesting point was raised by Arvind. in the context of evidence that is necessary during the time of judicial review. We have a bar in the high courts where examination is made only on the basis of the affidavits filed before the court. And if you argue a little further, courts will say, hands off, you go to the civil court if necessary. So there is, as of today, in constitutional challenges or the judicial review, there is a binary. On the one hand, you have civil courts alone to scrutinize facts and High Court and Supreme Court to scrutinize and judge administrative action. I was recently speaking on this very issue. It's an unfortunate situation that has come about. Time has come when we must grant our civil courts the power of judicial review, though they may not be able to interpret the constitution, they may not be able to set aside a statutory provision, but nevertheless, civil courts are entitled to restrain an executive action in exercise of judicial review. The powers are ample, but unfortunately, we have not gone on to the method. I'll just one more factor. Article 32, Arvind, sub-article 3,
Yes.
specifically empowers the party to make law to enable any other court, which means a civil court, to exercise judicial review for enforcement of fundamental rights, which means that the constitutional visionaries had thought that the time should come when civil courts can review judicially administrative action. That will to a large extent solve a lot of our problems where we have cases where fact and law are mixed together. It's a very important factor, as my friend had referred to. Now, coming to the main question that you had put to me.
I'm sorry to interject.
Yeah.
If I'm right, I think the Code of Civil Procedure already says that there are two things that I remember. One is the Code of Civil Procedure says that the civil court can refer any question of interpretation of the Constitution with a no. That's one thing. Secondly, if we recollect the PMA Metropolitan case, which says that the right to religion being a civil right is enforceable through the civil courts. If we abstract it a little further, any constitutional right is also a civil right, and it can be enforced through the civil courts, through mandatory injunctions or prohibitory injunctions, as the case may be. But we also find that people are reluctant to go to the civil courts.
Correct. Sorry. You have some question?
Yeah, the time that it takes and court fee, and even when we have...
That's a different topic altogether. It's some kind of an elitism of the High Court which has actually led to a situation like this. Because if you go historically, during the time of East India Company as well as direct governance under the Crown also enabled the civil courts to review the executive action very clearly. But we have done away with that process because once the fundamental rights were introduced, Part 3 came in from 1950 onwards. We thought High Court is the one-stop shop, which is wrong. I think the lot of reform can come in if civil courts are entrusted with at least to start with at the base level to scrutinize exercise of executive power. We don't need the civil courts to interpret constitution or even set aside statutes. The higher norm, the High Court and Supreme Court will lay down day-to-day challenges, which bulk of the challenge in the 226 and 32 are executive actions like notice not given, principles of natural justice not followed. Why can't all such matters be dealt in civil court? They have the power, they have excellent jurisdiction under the Specific Relief Act, declaratory reliefs as well as injunction reliefs, and statute very clearly prescribe even locus standi who can invoke. Leave it at that. Coming to your question, yes, I was a law officer only for 4 years, but most of my practice was on the civil side, and now again I'm a civil side and private lawyer, so to say. It's not really 100% correct to say that there is a reluctance on the part of the law officers to concede a position of that nature. See, bulk of the matters are ordinary matters. which don't get reported. About 80 to 90% of the matter are simple cases which are arising out of especially petitions or writs in the high courts where some service matter, something or the other. In most of those cases, the government pleaders or advocate general or the law officers of the Supreme Court invariably exercise discretion or are very accommodating. Because I see my experience, I've seen my colleagues also when I was there as a law officer but normal cases, that is how it happens. In fact, many a times court suggests to the law officer, why don't you look into it? Why should we answer this? So they go back, take instructions, come back, and then it happens in a routine manner. I'm telling you out of my experience. But a very small section of the responsibilities on the shoulders of a law officer relate to highly contentious cases. Those are the matters which get reported. Those are the matters in which people acquire or get an impression that matter is contested very severely. That gives perhaps the impression that why is it that a law officer is always opposing a matter, is not conceding the situation, conceding it. In such contentious matters, it becomes necessary that it is either a case where somebody is defending a policy or there are some political overtones in a matter, because we are dealing with public law matters. In public law, there are sensitivities. Like, for example, somebody would ask, why can't you have in a reservation cases, creamy layer for scheduled tribes or scheduled castes? Court would say, okay, why don't you look into it, take instructions. But this is sensitive matters. So just merely by saying, okay, we will take instructions, there will be a huge debate in the parliament. There are some very sensitive matters which law officers have to be extremely careful not to give an impression that they are easy about, because these are big principles. There are some cases, like many cases relate to social justice legislations. A judge might perhaps also not even know the implications of it, like Forest Rights Act. Many say that you are now contesting between an environment protection and permitting tribals. Judges who are used to for a very long time to protect the environment might say that why should you permit a tribal coming and then settling there, giving them pattas there. So in matters like that, it's policy translated into statute. So therefore one had to very strongly argue the matter. So this is the perhaps, and also third category would be purely political cases. Purely political cases. Now last 10 years, the Supreme Court and High Courts are filled with it. Cases are filed by political parties for political purposes. So therefore, they are very severely contested. There's no question of any give and take there, because the perspective, the purpose and objects are very different. They are contested matters. Having said this, I'm still saying that yes, you're very right. Why is it that today there is so much of a contest? If you look at the very fundamental principle which we keep forgetting all the time, this whole process of adversarial litigation is simply stated a methodology for inquiring into truth. So the Western philosophy evolved this concept of arriving at truth, which is the most difficult thing to find, by a mechanism of providing three persons. Petitioner who will argue, there is a judge sitting there, the other perspective is given by the other side counsel. In the process of dealing with fact by these two contesting lawyers, the judge will pick up a fact which is closest to truth. This is simply there's nothing more to our concept. Then you will see that there are no different role to an advocate than that of a judge. All three are doing the very same job, exactly the same job, because to enabling the institution to arrive at truth so that justice can be done. But in our practice, all of us forget that, because in our day-to-day practice, we are away from the larger principle, and then we are looking at a situation where we should either win the case or satisfy the government. So much so that, we little move away. That should not happen. And another thing, most important thing in this perspective is the independence of lawyers. If a lawyer takes a political position or confined to taking a particular stand always, all the time in his private life, and then incidentally comes and argues in a case, then in which case one knows that the lawyer will always argue a particular point of view belonging to a political party, or then there's a loss of independence of the profession. It's a very important point which has happened substantially to our position, to our judiciary in higher courts. That independence is. That is the reason why I'm saying somebody, a lawyer like Arvind, absolutely and totally, it's a rarity that such objectivity would be there in any matter. He would appear for anybody. But then that's not true with everybody. So therefore, independence of the lawyer coupled with constantly remembering the very purpose of this adversarial adjudication will enable any lawyer for that matter to give and take and adjust and help the court to arrive at the truth as early as possible and as easily as possible without much fight. That's my view.
I just wanted to with Mahesh doesn't mind. I think, in my experience, at least in the Madras High Court and Karnataka, Andhra, I've seen,
Yes.
but particularly in tax cases, if an issue is covered by the Supreme Court, I must say, in all fairness, the counsel says it is covered and then nobody contests it. So that you must give it. Even standing counsel also don't argue unnecessarily. And I don't blame them. You see, what Narasimha raised is an important point. Today, I may feel it's a question of law, I concede. It will hurt the state later, because if it's a question of law and you make a concession today, it may hurt you somewhere else unintentionally. So I think I don't expect the government advocate general or the solicitors, the additional solicitors like Narasimha to concede a point on a question of law. On a question of fact, or if the issue is directly settled by a Supreme Court judgment, then nobody wastes the time. So to that extent, they definitely do. And as you rightly mentioned on this in the civil courts, in fact, the courts had issued writs in specific relief act. There were cases where, in fact, Palkiwala's famous case that Kushal Das Advani was under the specific relief act of 1877. So you're right. Absolutely.
Arvind, even Silurmant arise out of
I didn't know that. Which one?
Cases.
That LT Somya, 54 Supreme Court.
Large number of cases arise out of suits.
Okay.
We have done away, unfortunately. I will discuss that with you. You may have to add it to your new constitution.
Actually, in Madras, for example, Madras High Court, about 45,000 writs are filed per year. Madurai, another 40,000. And quite a few of them is that I have paid my money, he has not disposed of my application, or this really need not come to the High Court. A court can issue a mandamus and be done with it at the earliest. You're absolutely right.
I was asking somebody, most of those cases are the collector has not issued notice. The collector should have heard me without hearing me. For that, they will run from Madurai or Coimbatore to Chennai. Now, of course. And why are we creating benches? Because you're saying it's convenient for people. Now we are thinking of creating a appellate court between High Court and the Supreme Court, because the High Court's bulk is carried forward to the Supreme Court. Instead, we have solidified and make the base strong and enable the civil courts to exercise judicial review at the base level. I think we will do much better.
A sort of connected point, and please correct me if I'm wrong. If I've understood it right, the idea of discretion in 226 should has its foundation in the concept of discretion in the Specific Relief Act. But in practice, it seems that connection is lost, and the civil law foundations of constitutional adjudication, that seems to be lost in
Yes.
My next question is to both the panelists. Probably I'll state what the proposition is. That so over the years we've seen this tendency on the part of constitutional courts, especially when it's a tough case or a politically sensitive case, as I was saying, to make a great declaration of law and then not grant any substantive relief to the petitioner. We see this right from Maneka Gandhi, and in recent times we've seen it in Anuradha Bhasan, the same thing. Now, there's also a big change in the nature of cases that's coming up before the court. Early years, you had people complaining about government action. There is a legislation that deprives you of property, or there is some property regulation and you're taking the government to the court over state action. Post-80s, with this explosion of public interest litigation, we also find a large number of cases where people come and say that I'm complaining of inaction, that the government is supposed to do something, they're not doing it, and that is what my complaint is. And I'm representing a whole bunch of people who are similarly situated. So with these two streams, that on one hand, this idea of lay down the law but refuse relief. At the same time, now people come to court saying that we won't relief because we are stuck. What would be the future of adjudication when we see both these things go on together? Probably I'll shoot this question first to Mr. Datar.
To me?
Yes.
Okay. I thought you'll ask Narasimha first because he's the right person. Anyway, see, you're right. Your question of grand declaration of law is not now. No, I basically think that every judge, I mean, even if I was a judge, I'd like to leave my legacy of classic judgments, pronouncements. Ultimately, we remember Vivian Bose, we remember Hidayatullah, we remember the great judges by the landmark judgment, Subbarao, the landmark judgments they delivered. So, obviously, and it's rightly so, every judge wants to leave some great pronouncements. But sometimes what happens is you have laid down a great pronouncement, but there is no justice to the litigant at all. And Maneka Gandhi is a classic case where there was no need to get into all that. You could have simply said, Mr. Gupte, who was Attorney General, he said that they will consider her representation. They could have, the High Court had disposed it off in just 2 sentences. But then you had Maneka Gandhi. Now, the only consolation is that Maneka Gandhi became the sort of the nursery, so to speak, or the crucible for a huge spawning of what you call the writ jurisdiction, limitations on administrative thing and so on. Take Royappa, for example. Ultimately, if you see Royappa, his writ petition was dismissed saying that he's challenging Rule 9. No fundamental rights are violated. They could have disposed of Royappa in 5 minutes. But they give a elaborate thing of arbitrariness in Article 14, cabin, confined, all those great pronouncements by Bhagwati. Take Ramana Shetty also for that example. I don't know if you know that, like, I must tell Narasimha that Ramana Shetty also arose out of a suit from the City Civil Court of Bombay. And ultimately, if you read Ramana Shetty, it's a huge discussion on the government's power of issuing contracts, tenders, and so on and so forth. But what did they do? They disposed of Ramana Shetty's plea on the ground of laches, saying that he came to court 4 months delay and his litigation was not fair. So there's no need to write such a law. So there is a grand declaration of Anuradha Bhasan also. You have laid down all elaborate principles that internet is a must and 144 this, that. But at the ground level, what is the benefit? So it's a grand theory, like Einstein's unified theory of law, something like that, which has no immediate practical use to anybody. So that is the point. Only thing is, like Maneka Gandhi, in future it will help somebody, that's all. There's nothing more than that. Take for example Aadhaar also in the event. A lot of discussions were held and all that, but ultimately what happened at the ground level? Yeah, thanks.
Mr. Narasimha, would you like any thoughts on that?
Okay. I think lawyers also must take blame for that. Because judge many times also indicates that, sir, there is nothing in this case. But then we go on and on, cite 101 judgments, tell them what America has said, England has said, and all that, and he will end up. But then on a principle, if you see, adjudication is multifold, threefold, so to say, that when a matter is taken up before the court, first thing is that the court requires to interpret the matter. So it will have to interpret either the constitution or the statute or whatever it may be. Once it interprets, that's the law part of it which it interprets. The second is that the court will have to apply the conclusion that it draws after interpreting it. And third is that it grants, therefore, the appropriate relief on the basis of application. Now, to say that court must not even entertain if it doesn't give relief is not correct as a principle. So it doesn't really matter for a court. Court will first of all, if it takes it up for adjudication, it will first interpret, then interpret the law, apply the fact and give relief. So as a principle, I don't agree that where you don't give relief, you should not interpret or give a big judgment. As a principle is not correct. But then the reality is this, that many cases, there is actually, I'll put it like this, Arvind, correct me if I'm wrong, I think there must be a distinction between precedent-making exercise and decision-making exercise. I think these courts have somewhere lost this for the reason that they are too much overburdened. You know, if they choose cases which require interpretation, require exposition of law, then their approach is not about facts. They will be focused on creating a precedent which is law making, which the Supreme Court itself as well as the high courts will follow, and entire district courts will follow. But what's happening in reality is every case which goes to the court, the Supreme Court said, give us reasons before we go to the high court. So they end up giving reasons, and they don't give good reasons. Supreme Court is unhappy. They pass strictures. They would say, they would adversely comment. So therefore, when a high court takes it up, there is a process by which they have to give semblance of reasons. There is no difference between some reasons and more reasons. So they end up in every case which comes before them giving a judgment. Even Supreme Court also does that. You know, so much of burden they put for final disposals. By the end of it, about 4 hours of arguments or 3 hours, they would reserve, they will have to pass an order, though they would have made up. It doesn't take much for a judge to make up his mind, but then it takes a long time for them to write a judgment. So much of time is invested in these. So there must also be a mechanism where we get over this problem, Arvind. This is a very serious problem, what our friend is referring to. It is a serious problem. You draw the distinction between decision making, because 136 jurisdiction, you don't need to do anything. You take a decision, but they must decide which is the most important case on which principle need to be set and the precedent to be made. Most of the judgments, everybody will agree. The Supreme Court judgment, if you open and then look through the pages, you will say, we have already held about 13 judgments are there. Then they will say, therefore we hold. So why so many judgments then? So I think we should, that's an important factor that we must take care. But as a principle, of course, there's nothing wrong in the principle of not giving relief.
I got one thing to add. As you rightly say, yes, one is precedent making, one is decision making. And to tell Mahesh, sometimes what happens, you have a precedent without a relief. Sometimes you have precedent and relief. And then the next step is making the government or the other party follow that relief. And the worst is for we tax lawyers, we succeed up to the Supreme Court, and the next budget they retrospectively amend the law and nullify the entire benefit. So we are back to square one. Recently, the Delhi High Court said something on GST credit, that you can't deny the credit, you can't deny the carry forward period. And the judgment was given on a particular day. Within 10 days, the Finance Act overruled it retrospectively from 1917. So all this litigation of all the courts has been reduced to naught. So the relief which you got also is eventually nullified, which is also a very disturbing thing, but it's the reality of Indian life.
Yeah, we saw that in the Aadhaar case also, something that was struck down. There was a legislation to validate that later. Yeah. Probably what I'd like to interject here in between is a question: what is PILs playing out in this whole scenario? One is that there are really indefensible ones, not just political, they're just for showmanship. Some of them are outright stupid, but we find that the courts are entertaining many of them. Someone who had just pointed this out, that over the last 5 years, the Supreme Court has entertained 5 PILs on the request that we must change the name of India to Bharat. And every year such a PIL is admitted, kept on the books for some time, and then it is sent back saying that the representation needs to be considered. On the other hand, there are of course genuine matters that also come up before the court. And if we look at the history of public law, especially environmental law in India, a lot of them were generated through PILs at the end of the day. So what is the direction that this PIL system is taking in the future? And what do you think would be its impact on the development of public law?
Narasimha, you can start.
Yeah, PIL is a very big issue which we need to deal with. To start with, it was a beautiful exercise of power. I mean, I think it is an act of fraternity. Why I say fraternity is that anybody could have gone to the court for a remedy in the event there was a violation of his right. But what is PIL? PIL is, I am okay, but my brother or sister is deprived of a fundamental right and I carry it forward. So that's how locus standi issue, which arose then, was done away by the court by saying that there's nothing wrong if a brother brings it to the court. That's a beautiful exercise of jurisdiction. And then it moved on from time to time, and it's a great study. I had spoken on this, and I think so many people have written on this. It had gone on to this. I will just temp many stages in which, and finally the difficulty has come in a situation where public interest litigation would give somebody a standing and he gets a focus also. So this gave an incentive for people to go to the courts. That is one. Second is, in a private matter, there is consequences to your petitions. If I am doing something on behalf of my client, I'll be careful. I will ensure that the case is not dismissed for with costs or something like that. If I am filing in my own name, I will again be careful. But PIL has no consequences, right? Somebody can knock on the door of the court. It could be absurd, but it doesn't really matter. So therefore, he walks into the court, petition gets dismissed, he goes back and prepares another petition. So therefore, that advantage that one had to carry the matter on behalf of somebody else for whom you would pray has now got into this problem where you don't need to care about the consequences. Petitions after petitions are filed. So therefore, court will only do in only few cases that they have dismissed with cause. But how long? I think it has now done, unless somebody shows that there are serious consequences for this, or the court imposes very many restrictions on that, this PIL jurisdiction is, we can't do away with it at the same time. It's a very important jurisdiction. I'm not one of those who is not going to say that PIL should be closed. But it must be very, very with great, the restraint must be exercised by the lawyer who is filing. I think it's our responsibility. I put it that. Arvind?
Yeah, actually PIL came around in the mid-80s. It started in 78, 79, etc. But the real PIL started in the 80s after the Sriram gas leak and MC Mehta's cases and so on and so forth. See, like anything, I think basically we should fundamentally understand that a PIL very often happens because of the failure of the executive to do its statutory duty. The common example was the numerous matters which came before Kuldeep Singh in those days on pollution, where they found that despite widespread pollution, etc., notices were not issued on 80 or 90 pollutant industries. So the court took upon itself and started issuing directions. So if we analyze PILs, I find that they are basically in the area of environment, in the area of human rights, and in the area of policy issue. For example, electoral bond, whether it is electoral bonds are there or not. Your bearer bonds was raised by R.K. Jain in those days. So these are the issues which have come again and again. I think we must accept that PIL is not a necessary evil, it's an affirmative good. It is something positive, it's something unique which we can be proud of contributing, that you have a relaxed locus standi, you don't stick to the rules of strict rules of evidence and so on. Like which kind, I mean, how do you expect the sexual harassment like Vishaka to come except through a PIL? How do you expect, like Narasimha was in the forest? I think a large part of deforestation has been condoned, stopped only because of a PIL. In fact, I was in Andamans and there were some wooden cottages were there, and someone told me that man was telling me all these are imported from Thailand. Because of Supreme Court orders, we can't cut trees in India. So it was a positive thing that the entire forest litigation, the coal mining, etc. was there. Now, on the minor side of it, what happens in PIL is very often these disputes are polycentric. The Supreme Court passes an order without realizing the consequences, or a High Court passes an order without realizing the collateral damage it does. For example, you take coal. You simply say that all coal licenses are cancelled, all 2G are cancelled. All coal people should pay 200 rupees per ton. On what basis? There is no thing. Take, for example, the banning of liquor on 500 meters. The kind of havoc it created because people had licenses, people had paid license fees for liquor shops, hotels were shut down, marriage halls were shut down. So it created a lot of things. Like simple thing of the court banning diesel about 2-liter cars. This is also a PI which perhaps the court should see that before, you see, because what happens, one environmentalist comes to court with a particular agenda, he genuinely believes that his cause is right, that diesel is more polluting than petrol. But then that's a matter of policy decision. So I think as far as, I would summarize by saying PIL is definitely a positive aspect. But like Narasimha says, first thing I file is that people rushing to the Supreme Court should be an exception. They must first ask to go to the respective high courts. Only if it is something concerning pan-India, they should come to the Supreme Court. Otherwise, first let it be only with the high courts. Secondly, there must be a very clear system of costs and standardized costs. Not in one case they put 5 lakhs, one 10,000. They can say that any PI which is frivolous will suffer 50,000 costs or 25,000 costs. Thirdly, there must be a scrutiny of local standard. Now, what's happening is, in the guise of PIL, there are motivated PILs. But particularly in the case of tenders and licenses and permissions and so on, you have some rival, you have some group of so-called NGO, which has no locus, no backing, and it is suddenly put up to challenge the allotment of a license or the particular policy decision is challenged. It's obvious that your top-class senior counsel appearing for them, we know that this particular NGO could not have the wherewithal to sustain this kind of litigation. So I think a certain element of judicial scrutiny before opening the door should be followed. And I think Narasimha makes the most important point of cost. Today, what happens is you can file anything in court. The other side may have to engage lawyers. You may incur several lakhs in cost. And ultimately, the case will be dismissed with no order as to cost. Why should anybody suffer for that?
I will share something with you, Arvind, and our audience, and Mahesh also. In 2014, when I was appointed as a law officer, Harish Salve called me, and he said, law officers' role will become important in times to come because of the shift in contest from the floor of the house to the floor of the court. I didn't really understand his statement fully till work started coming. In the cause list that I had every day, if I had about 12 cases to argue, of which about 6 to 7 were PILs. So, most of the law officers today are handling PIL cases, then very important cases. Some case or the other, some issue or the other, just file PIL. And the court also is a little sensitive. You can't straight away throw away the matter because it is all covered under the garb of, oh, great harm is being done. So court will definitely look into it. So you get instructions, you look into the matter. So matter won't be dismissed at the admission stage. It goes on and on. The most difficult part of it, which the Supreme Court had to handle in PIL, arose when PILs with political overtones started getting filed in the court. That is the most difficult part of it. What happens is, court is invariably asked to take a stand. I was telling you that there are petitions which are politically filed. So everybody knows the bar is divided. Everybody knows clearly who is filing, for what purposes it's being filed. But for a court, as a lawyer, it doesn't matter. For a court, it has to take a stand. So when court takes stand on this side, there is an accusation of pro. It takes on this side, gets an accusation that it is against. So it's a very difficult task for the court. Court got into it. Politics entered. Lawyers having filed such petitions, it's all right. But then the petitions having been filed, I'm talking a matter which has troubled the court for a long time. Petition having been filed, what can the court do? It walks into it. It has to walk into it. And it walks into it, obviously everybody will say that, oh, today the case got adjourned. Obviously it got adjourned. Judge did not sit because of such and such reasons. Somebody from this side will say, suppose the judge is little firm saying that why this petition, there's an overtone about, oh, the judge is saying like this. There is a danger now in public interest litigation which has political over. These are the matters which the court should not touch even with the large scope. But human rights, as Arvind is very correctly saying, human rights, environment matters, yes, the court must exercise. In fact, we have made great progress, but we digressed in political matters. Court got disreputed, lawyers got, even we have got disreputed. Because people say that, okay, we are aligned one way or the other. That is why I was stating that the objectivity of a lawyer is as important as that of a judge.
Mr. Datar, any comments on that?
No, he's absolutely right, because what happens is, only one thing is, sometimes what happens, it's a PIL, it is got political overtones because perhaps the ruling party passes a particular legislation, it's got majority, but it pushes through the legislation. Then where do you test it? So you test it only through courts. Then it's a case where rights are involved and the policy decision is taken. Say, for example, suppose hypothetically on a particular issue, the legislature, as per its own what you call political manifesto, it takes a decision on, let's say on reservation, for example. Now, you take the Maratha reservation, there was suppose the mandate is, I'm going to give reservation for the Maratha community, and it goes to court. Definitely it's got political overtone, but what does the court do? It has to ultimately decide whether you can cross 50%, not cross 50%. But if it is a political motivated PIL with no writ, then definitely. I personally feel that there should be some kind of practice directions, perhaps the Supreme Court, like the UK court, can lay down that these are the fundamental parameters which are like some kind of a filter before the matters entertained by the High Court or by the Supreme Court.
So, yeah, as Mr. Narasimha was pointing out, I think one technique that the courts adopted is to not really pass orders, but take instructions, wait for some more time, take multiple adjournments, and keep pushing it. But the worrying thing that I see is also that probably this strategy is now being applied to cases which has some political overtone, but are nevertheless fundamental human rights cases, like habeas corpus petition, for instance. The court issues notice and then posts the case after 8 weeks. After 8 weeks, again, there is an adjournment for 4 weeks. And these are matters of personal liberty, but it just gets dragged on. Often the government is given a very long period of time to file a counter affidavit. So the strategy that the court probably picked up from political PILs have now been applied to other contexts where there is some kind of discomfort that's involved in deciding that case. As a public law lawyer, especially for petitioners, how do you really engage with this difficult situation?
You're asking Narasimha or me?
It's a question to both of you, but probably you can answer first.
Yes. You're right. What you mentioned is the point, like former Prime Minister Narasimha Rao said. He said that not taking a decision itself is a decision. So I do want to take an uncomfortable decision, just push the buck, put it after 4 weeks, file counter, file rejoinder. And one senior lawyer in Bombay called it the Houdini trick, the escape trick. You don't take a decision and you just pass it on. Sometimes it's, sometimes it may be necessary because if tempers are very high, if the atmosphere is very vitiated, as part of a cooling off period may be there, it may be worthwhile postponing it beyond a particular time on a particular situation. But my personal views on habeas corpus, it is absolutely imperative that it is taken up at the very, very earliest. There is no question of adjourning it by 4 weeks, 8 weeks. Not only now, I've seen in the other high courts also, where the Gundas Act or some act, the detention is 1 year. By the time the matter is heard, 11 months are over. So the guy has already spent 11 months in jail. What's the point is getting releases? It wipes his record. Record is clean, but he has suffered for 11 months for no reason. So habeas corpus should be taken on absolute priority. There should be a rule that any habeas corpus will be decided within 4 weeks or within 3 weeks, whatever happens. And see, in habeas corpus, the point is very simple. Is the detention is valid or not? And especially if it's not under, when I was a junior, we had large number of coffee poser cases, where smuggling act, and then, the copy not given in his language, a standard defense is taken, and the matters would be taken up. But where there are people incarcerated without trial, then habeas corpus is very, very important. And apart from that, there's not only habeas corpus. The other dangerous thing in India, I find, is that your criminal justice system is jail him first and try him later. That's a very unfortunate part. Whether it is GST or PML, etc., you put him in jail. 90 days he spends in jail. 6 months he spends in jail. And the other dangerous thing I find, and I think Narasimha will agree, if it's a sensitive matter, if it's a sensational matter, the odds of your getting bail are almost nil, unfortunately. Nobody will come and boldly say, yes, I'm going to give you bail. So we have to do some serious thinking on this particular point, both not only in courts, but also as a matter of policy. And the other point is, even on the part of the union, I've seen in my own cases where a completely misleading report is leaked to the press, and they make allegation that Mahesh Menon has got 1,000 crores in a bank account, etc. And then you find that it is not actually true. But then you're pronounced guilty there. As far as society is concerned, you're condemned. Who cares what happens after 2 years? You're tainted in society.
Mr. Narasimha, your thoughts on this?
No, I completely agree with him. There's no two thoughts on this. On this issue, I'm completely with him. Habeas corpus, the most urgent matter. You can't just delay it.
I think closely connected to that too is how often the government is probably targeting lawyers. I think there's a lot of international human rights material on the idea that ensuring that lawyers can independently perform their function is as important to a rule of law system as any other thing. And we see some recent cases where there is probably a fear that the lawyers themselves have about retribution from the government. In your long career in litigation, did you ever encounter such a scenario? Maybe if not personally, any who had to go through this, and then how is this dealt with, or what would be the strategies to deal with this problem?
In my whole career, I came across. Sorry, Arvind, you were saying something.
No, please go ahead. Please go ahead.
Only one case, I think Shabnam Loan from Kashmir. There was an arrest, and K.K. Venugopal went to the Patiala court to get a bail for her. I don't remember instances where lawyers were put in bars and then they had to rush because they appeared for somebody else. And I think our system is robust enough to handle a situation like this. We have remedies available. Our press is strong. And if any action of that nature is undertaken, I don't think our institutions will keep quiet. We have remedies available. It has not gone to that extent of retribution against lawyers for having appeared, at least to my career. I don't think, and it's not possible in our country also. Arvind?
Yeah. Well, I can say that after 40 years, I have not faced a single case of any kind of fear, or I have appeared in quite a few sensitive, sensational cases, quite a few where the stakes were very high, and in different parts of the country, and I have not had a single case where I felt that some kind of fear was there or pressure was there, not at all. So, in all fairness to our system, whatever it may be there, I think lawyers can discharge their duties fearlessly, and that credit must go to our democracy. And I don't think that's part. In other countries, your life is threatened, but in India, we are blessed to live in a country where we have got this oxygen of freedom to do whatever we like.
Yes.
The only unfortunate thing is, what I feel sometimes is, because of the polarization of the bar, as Narasimha put it, you're belonging to a particular party, etc., then you're just not able to see the other point of view, and then that, because we are primarily, in terms of fraternity, we are members of one profession. We may have political leaning, but that should be outside the court. Once we come to court, it should be a completely neutral platform where we all are engaged in the task of doing the best for our clients. That I think should be there, because in South India, for example, you have XYZ parties advocates wing, and which I thought is very absurd. You can't have an advocates wing and then people being there. It's okay. You can lean towards the Communist Party or Capitalist Party, whatever it is. But I thought that should not be there. But to answer your question, there is no retribution at all.
Okay, probably this is a fear that I've heard from especially lawyers who practice on the criminal side in the smaller towns and in the non-high court areas.
You see, but no, I'll tell you what, that may be there from rival gangs or something like that. I don't know. But from as far as the state is concerned, I don't think they completely respect our independence. That's my view.
No such
and that, yeah. And at least in Tamil Nadu, I don't find any advocates being ever threatened. In fact, because the bar is so strong. If anything is done, I know a case where there will be a complete boycott at that particular point. So the bar is very, very strong, perhaps more strong in Tamil Nadu than anywhere else. So no, I don't know where your data is, but I would say that in Tamil Nadu, the answer is
right. So my last question is for young lawyers who are looking forward to a career in public law, what would be your advice for them?
If you talk of public law, which means basically we've been discussing public law, and I understand public law is in contradiction to private law, where the litigants is not private individual versus private individual, but it is between the individual and the state, or that's the definition of public law in Black's Law Dictionary. And the other definition is that public law is concerned with the structure of government, how the three organs of government are, and we don't have the fourth like religion like in England, but how the organs of government function, what are the interplays, what are their balance of powers, etc., etc. That is there. I personally, I've said this on a different platform, but I think every young lawyer should first master civil law and criminal law as a procedural law, and then go to public law. When you say public law, you mean basically Article 226. And a large part of the public law again has gone off to tribunals, like service tribunals have a large litigation. I mean, I don't know, Narasimha will correct me, but I was told at one time almost 30 or 40% of the litigation in Supreme Court was either criminal or service, because you had a complete service jurisprudence going, which got substantially reduced because of CAT and SAT. They got filtered out and they went to the High Court, so very few cases ultimately went to Supreme Court. So advice to young lawyers is, I would personally say that you have one area of specialization, say income tax or patents or copyright, whatever it is, and then do public law as a kind of a pro bono thing where you hone your constitutional skills. I think it's very difficult to sustain a living only on public law. That may not be possible. You must have one area of specialization. It could be criminal law, it could be civil law, it could be any specialization in tribunals. At least that's what I did. I had basically a good tax practice, and I used to do all these PILs. I started appearing with the green bench in those days in environmental matters, PIL matters. I did all these tribunal cases for the Madras Bar Association. That was a huge boost to myself personally also, because I learned a lot in the process. So, but all that was completely pro bono. And like in Narasimha knows, in 2 years ago, almost the entire year was a pro bono year. Aadhaar, you had the privacy case, you had the 377 case, the armed forces case, all were pro bono cases. So I tell a young lawyer, have an area of practice which is your bread and butter, and keep public law as the jam. Food for the soul. I don't know if Narasimha agrees with me, but yeah, he has much more public law experience than me. So
it's a very practical suggestion that you have given, and you have very beautifully evolved from out of practice in corporate and tax matters to public law, and you've given very good suggestions. Somebody like me, born in Red Court, and stayed in Red Court. If I share my perspective, I think a public lawyer must read our freedom movement. I think public lawyer must know the history of our country, must know very importantly political science. Why I'm saying this is, there's one thing which I want to share with Arvind also. When you go to the court and contest in the context of your rights or the powers of the state, what happens is that you go to fundamentals of where we stand, what we are, what our identities are. When you raise questions like that, your history becomes very important. Your identity becomes important. And you can't read them overnight when you're arguing a case. You will have to slowly evolve in public law. And why I'm saying another point, I will stop with this, is till in 1950, we got territorial independence from colonial rule. But I believe that intellectual colonialism is still continuing. Our vocabulary, our ideas, our concepts are all hedged in the language as well as the structure of our law. Unless you become independent of it and begin to interpret it in the manner that you understand this subcontinent and understand our people, we will not be able to pull ourselves out of colonial control. Like, for example, simple issue like the definition of a religion. You go by Oxford English Dictionary, then you miss the bus. You don't understand the country. Then how do you? Then you should know what the country is, what religion is for us. How did we understand religion? This is public law. This is what we need to get to know and break those shackles. A lot of our senior counsels have over a period done it, but then it still continues in various aspects of it. We are still hedged in our, even concepts of freedom, concepts are all in the same narrative as it was told to us. So we need to reinvent ourselves. That is what public law requires us to do. But we must not miss the advice given by my dear friend that if you go into public law with this perspective, as a lawyer, you'll have to leave practice. You have to, first of all, focus, get a foothold, and then evolve as many has done. That's it. That's all that I want to say.
I wanted to also add to what Narasimha said. In retrospect, I feel very sorry that we were not taught history. For example, I learned about, when you talk of separation of powers, you think of Montesquieu. But how many of us have actually seen Montesquieu, read Montesquieu or read Locke or read Hobbes, the Leviathan and so on? These are all fundamental. You know, I first heard of Montesquieu after I became a lawyer. I did my BSc honors in mathematics and physics, and we did law, 3 years of law. Nobody did no course. So I think you're very right. Apart from the legal history of the Sadar Divani Adalat and all that, some other history should be there. You can learn about the Niti Shatak, the Rotary Shatak, own history on legal history. And political science is very, very important. What are the schools of government? We should read Montesquieu, Locke, Hobbes, Chanakya on all these things. Artha, Kautilya should be taught as a course. That's my personal view. At least 100 marks paper should be there.
Yeah, I think the points that both of you raised, I think a lot of the blame should go to my tribe, legal academics. So you've done precious little to really try and develop a Indian jurisprudence or jurisprudence that's relevant to the context of India. We've pretty much tried to follow what the West said and try and fit those theories.
You see, but I've got a basic thing, people say about the West. Now, whatever it is, we got Evidence Act from 1860. There's no substitute for that. You got the CRPC, it is working well. You got the CPC. There's a very old civil law in Madras. He said that if you just follow the CPC, a trial should need to get over in 2 years. You don't follow what is written there. For example, you say in consumer court, the matter should be disposed of in 3 months, but its case are pending from 2005. So the fault is not with the law per se, the fault is the execution. Everywhere we falter because of the faulty implementation. So I don't believe, people say you must have almost throughout the complete British system and so on. Whatever it is, it has served us for 150 years. You take that and you get good principles of it. Like Narasimha rightly said, you can't blindly adopt like in the Sirurmat case, they simply took the Oxford Dictionary for religions and you're still suffering religious denomination. They just took it blindly from the Oxford Dictionary. So that is there. But for some people who say, no, that must go back to the Panchayati Raj, etc., maybe slightly difficult for civil disputes. And We are now used to this particular system we can do. Only what I feel is that the other thing I feel is that the English has suffered greatly, because now there's an increasing clamor to have only vernacular local languages in the district court. So maybe we should have a system where advocates who don't want to come to the High Court should be allowed to practice in their local languages. That's another major area which outside today's discussion.
I also agree.
That's probably a final last line that you've both been getting a lot of junior lawyers. Both of you have contributed a lot to the bar by raising a whole bunch of excellent junior lawyers. Where do you see is legal education need to gear up when it comes to having good lawyers who are skilled in doing public law? What are the lackings that you've seen when you've seen the interns or seen the juniors?
See, I over the years, I find that the quality of interns is really outstanding, especially people who come from the law schools and so on. Their knowledge is at a very high level. I keep telling them that, what I did not know at 30, they know at 20. So they're exposed to much more. A great part of their great advantage they have is the access to the net. They're technically very savvy. So they're able to get immediate tips, immediate things on the web. You ask them something like Montesquieu, you go to Wikipedia, everything is available on the spot. So the young interns are very bright. In fact, as far as public law is concerned, I don't think you can blame the law schools or expect law schools. This public law will come only after you get into the practice per se. So I have no quarrel with the interns and all. My only point is, as far as the law schools are concerned, I would prefer that they're made ready for the outside world. Like I've been pleading for the last 30 years with all the law schools. In the final year, have one paper on accounts, because people are going to do commercial matters today and they have no clue of what's the basically double entry system, what's the profit loss account, what's the balance sheet. So you expect people to do cases of SEBI, company law, but they don't know anything. So that is a very, very important area which you should have. And then the specialization should be of much greater rigor. I also wanted to, I don't know what happens now, but when I was in law school, we had an elective of interpretation, which I thought was the most beneficial to me. 100 marks paper only on interpretation, and I got my first copy of Maxwell, the blue color book, in those days. So I think students must know interpretation, must know accounts if they want to do commercial practice. But I think it's very important that they know that.
Mr. Narasimha, your thoughts?
I am very afraid Arvind has introduced accounts. Had it been there during my time, I would not have passed law.
No, you would have passed. You would have passed law.
I would not have passed law. Also,
I told Mr. Surabji, who was the governor of one of the board of governors of National Law School, Bangalore. I told other law school governors, I've been going to different law schools for lectures. I said, you just do intermediate accounts, up to Schedule 6 balance sheet. What's a company balance sheet? Learn the basics. I'm not asking you to solve a complex paper like a chartered accountant, but at least the basics you should understand. And because many of the lawyers are going to become judges, they're going to join tribunals. If they have this basic knowledge, it will be helpful.
So thank you, both of you, for taking out time from your busy schedules to join us in this conversation. I think it was a very enjoyable conversation that we had. And thank you so much, Mr. Datar, for pointing out the need to build a couple of skills that real-world lawyers or practitioners need to have, because the Daksha Fellowship is all about that. To the audience, we are very proud to say that Mr. Datar is on our panel of advisors, and yes, accounting is one of the things that we have that we'll be teaching at the Daksha Fellowship. The applications for the fellowship are still open, and I would encourage all of you listeners to apply if you are eligible for it. We'd love to see you join us in these sort of conversations. I'd also hope to see Mr. Narasimha attending or being with us in future panels too, in our classrooms to share his wonderful experience. And probably we'll organize more panels where we can get the two of you to talk, because it's been a wonderful experience to listen to two of you, and it's been a great experience for me to moderate this session. Thank you so much for taking the time out and joining us. And for all the attendees, we are still accepting applications, but it's due to close very soon. So I would encourage you all to apply for a fellowship with the earliest. Thank you very much. Thank you very much.
Thank you very much for giving me this opportunity.
Thank you.